Good morning, ladies and gentlemen. I'd like to call this meeting to order. I want to welcome everyone to our final board meeting for the year of 2022. My name is Malia Cohen. I've been chair of this body, and it's been an honor to serve the state of California. To my left has been the vice chair, Mr. Mike Schaefer, and Ms. Cicchetti. Good morning. Could you please call the roll?
Good morning. Chair Cohen.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines. Absent. Member Vasquez.
Present.
And Deputy Controller Eppolite.
Present.
Fantastic. We have a quorum. We will continue. Ladies and gentlemen, if you are able, please rise and place your right hand over your heart and repeat after me. We're going to say the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, folks, we are going to take a couple items out of order today, and we are going to begin with item J. Ms. Cicchetti, please call item J.
Before we start, we have our normal information announcement that needs to be done.
Please.
Good morning, Madam Chair and members. The board meeting information announcement is as follows. First, we'd like to remind the audience to silence your cell phones and any other wireless devices. The current COVID-19 guidelines for the Board of Equalization strongly encourage, but no longer mandatory, that all BOE employees must wear a mask while inside any BOE facility or while attending any BOE event. If needed, supplies of masks and hand sanitizer are available to all and can be found at the back of the auditorium. Public comment is taken on each agenda item. The public will be invited to comment during the matters before the board. If there are any members of the public wishing to speak before the board on an agenda item in person, we ask that you complete and submit to the Sergeant of Arms a public comment appearance sheet located at the entrance of the auditorium. If you wish to speak before the board by telephone, please dial the phone number and access code provided on our public agenda notice and follow the instructions from the AT&T moderator. If you intend to make a public comment today using the AT&T moderator, we recommend dialing into the meeting on the teleconference line prior to the beginning of the agenda item you wish to make a comment. We recommend that this, as the audio broadcast on our website, experiences a 1 to 3 minute delay between the live stream and the live event. When giving a public comment, please limit your remarks to 3 minutes. The order that the board identifies public comments at the conclusion of an agenda item is as follows. The clerk will first identify any public comment requests that have been received by our board proceeding staff in the auditorium. Then we will identify any public comments on the AT&T moderator. And lastly, we will read into the record any public comments received in writing in advance of today's meeting. This concludes the informational announcement. Thank you.
Thank you very much, Ms. Cicchetti. We appreciate those reminders. Would you please call the first agenda item?
First item for today is J, Administrative Session, Administrative Consent Agenda. Consent items are approved with one motion unless a board member asks for discussion or a separate action on any listed item. Therefore, we will be taking these 4 consent items up with one vote. J1, adoption of board meeting minutes for November 17th, 18th, 2022. The minutes of the meeting were attached to the public agenda notice for your consideration. J2, approval of Assessor's Handbook, Section 531 for 2023. Request approval for publication of the 2023 version of the Assessor's Handbook, Section 531, residential building costs. J3, approval of Assessor's Handbook, Section 534 for 2023. Request approval for publication of the 2023 version of the Assessor's Handbook, Section 534, rural building costs. J4, Approval of Assessors Handbook, Section 581 for 2023. Request approval for publication of the 2023 revision of the Assessors Handbook, Section 581, Equipment and Fixture Indexes, Percent Good and Valuation Factors.
All right. Thank you very much. Colleagues, first, are there any opening remarks on any of these items? Any discussion? Do you have anything to say?
It's my birthday.
No, not now. Okay, let's,
You want me to move the item?
yeah, let's take a motion.
I move that we adopt the minutes as submitted for today's November board meeting and adopt the staff's recommendation regarding the approval of Assessor's Handbook, Section 531, 534, and 581.
All right,
Second that motion.
Thank you. A motion has been made by Mr. Vasquez, second by Mr. Eppolite. Let's take public comment, please.
AT&T moderator, is there anyone on the line who'd like to make a public comment regarding this item?
Ladies and gentlemen on the phones, to make public comment, please press 1, then 0. An operator will gather your name and place you in queue. When you hear your name called, you may proceed with your comment. Once again, press 1, 0 to comment, please. Madam Chair, we have no respondents by phone.
Thank you.
Thank you very much. Mr. Kitty, could you please call the roll for the vote?
All righty. The motion is to approve all consent items by Mr. Vasquez and second by Deputy Controller Eppolite. Chair Cohen,
Aye.
Vice Chair Schaefer,
Aye.
Member Gaines, Member Vasquez,
Aye.
Deputy Controller Eppolite.
Aye.
Great, thank you. The item passes unanimously. Mr. Getty, could you please call the next item?
The next item on the agenda is K, Other Administrative Matters, K1A, Executive Director's Report, Organizational Update, Report on the Status of Pending and Upcoming Organizational Priorities. This matter will be presented by Ms. Dowers.
Good morning, Chair Cohen and honorable members. I'm Yvette Stowers, Executive Director. As we approach the end of the year, the end of your first term, it is fitting to look back and acknowledge that this board was instrumental in providing the invaluable leadership that led to the many successes we have had and achieved in the past 4 years. With the board assistance, I am confident that more taxpayers and stakeholders are aware of what and who we are and the critical role that the BOE plays on the behalf of the state and local governments. Also, I want to take the opportunity to thank the board for their support on the agencies in their work on the agency's 2020-2025 strategic plan. We have made great strides in the implementation on our strategic plan, having rebuilt the agency's administrative infrastructure and modernizing many of our processes. We will continue to modernize, rebuild, and revitalize our agency so that we will remain highly valued and effective state agency serving all of California. As you are aware, later on in the agenda, the board would also have an overview of the board's accomplishments over the past 4 years. Even though the year is not over, I'd like to highlight a few of the agency's accomplishments for this past year under your leadership. To date, the County Assessed Property Division has issued 55 letters to assessors, published 11 assessment survey samplings. Additionally, in 2022, we increased the number of our courses to 33, which is 10 more than last year. The State Assessed Property Division has produced and adopted the 2022 Board Roll of State Assessed Properties with a total assessed value of over $136 billion and transmitted the values to the 58 county auditors, representing approximately $2.16 billion in property tax revenue for schools and local governments. and they have produced, adopted, and billed the 2022 private railroad car tax for a total amount of $9.7 million that will go to the state's general fund. The Legislative Research and Statistics Division has tracked 57 Assembly and Senate bills in 2022 and issued 42 bill analysis. The Communication Department has led the effort in creating several new translated publications that contain general and static information, including Prop 19 fact sheet in Spanish and in Chinese, as well as several taxpayers' rights informational sheets. Additionally, we are projected to have 70 social media posts on all of our channels by the end of this year. And finally, the Board Proceedings and Support Service Division has planned and implemented 9 in-person hybrid meetings in 2022 and 3 remote meetings using Microsoft Teams. They have facilitated 47 job recruitment announcements to the agency's employees and external partners, prepared, facilitated, and submitted 42 hiring packages, and completed the onboarding of 22 employees new to the state. That was just a taste of the business that we have accomplished this year. Members, I am continued to be thankful and appreciative of your leadership and support to move this agency forward. Once the year is concluded, at the January 23 meeting, I will go into further detail on the agency's accomplishments. I believe this will be a positive way to set the tone for the new year, as well as orientate our incoming board member of all of the good work that the agency has done. Next, members, I would like to once again extend my appreciation and thanks to the outgoing California Assessor Association President, the Honorable Leslie Morgan, for her partnership in 2022, as many of our accomplishments were achieved through great collaboration with CAA. Moving into the new year, I'm looking forward to working with the Honorable Christine Lee, the incoming CAA President of 2023. Finally, members, I'd like to wish you and the agency staff a very happy and healthy holiday season. If there are no questions, I am prepared to ask Ms. Renati to come up, but I'm open for questions as well.
Are you open for comments?
I am.
Thank you for the report. It's actually important for us to take a moment to step back and just reflect on our accomplishments. Oftentimes, we lament the growing pains and we ignore what we have actually accomplished and how we're moving forward. And I would like to just extend a compliment to you and to the growing team. Many folks are new on the team and have gelled and are fully executing, I think, the vision that we had set out years ago, increasing, filling vacancies, our forward-facing website, being mindful of the content that we're uploading and putting forward and up in social media, the increasing the course load. I mean, these are things that we have heard through a lot of our feedback and intake process over the last several years, and I kind of feel like we are finally getting our footing and moving in the right direction. It feels good. So for us to just sit back at the end of the year and just reflect, I'm grateful for that report and proud of the work that Ms. Fleming started and that you, Ms. Stowers, are in the process of actually completing and also in many ways continuing other agenda items. So my compliments to the staff, those that are transitioning and retiring and those that are new that are coming on board. It's just a very interesting time for the Board of Equalization. So I don't have any other questions or comments, colleagues. Mr. Vasquez?
Yes, I would just ditto the chair's comments, and I would just ask, traditionally I know we schedule a summary at the beginning of each year with the state's physical outlook. As you know, I guess the LAO, is the one that publishes that the physical outlook report to prepare us for the upcoming state budget process. And in their analysis, they make assumptions about the future of the state economy, the revenues, the expenditures, which is helpful for us as our assessors and others as we begin the new year. And I was wondering if it was possible maybe to get a summary of it at our January meeting coming up.
Absolutely.
Thank you.
Thank you. Anyone on this?
Before we go forward, do we want to take a motion on that?
Let's finish comments, and then
Okay.
we'll get that motion going, and we'll take public comment. Mr. Gaines, good
Yeah.
morning.
Yeah, great. Good morning to all. I hope you have, I know you've all worked hard and you've had a victory, Malia. Congratulations on that and moving forward. And to each of the members who are elected to their position, re-elected. But I just wanted to, if I could just add on in terms of the great progress, I think Chair Cohen put it very concisely in terms of the progress that's being made at the Board of Equalization. And it is very encouraging, and it's taken several years to get to where we are, but it is all positive movement. And when we take a look even at Prop 19 and having to integrate Prop 19 into a staff that was limited, right as we were trying to also ramp up that staff and fill the vacancies, along with all the other accomplishments that have already been mentioned. But Prop 19 added additional pressure, and so it's nice to see that this board and the team, the staff, have done such a great job in terms of executing. And here we are now entering into a rougher sea in terms of the financial impacts with a potential $25 billion deficit that the administration and the legislature will be working on. But as far as the Board of Equalization is concerned, very encouraged that we've lived in our budget and feel like we are operating efficiently, and by just filling those vacancies, making great progress. So thank you, Yvette, for all that you've done and the entire team.
Thank you.
Thank you. All right, let's go ahead and take a motion.
Before you restate the motion, Member Vasquez,
Yeah.
I understand what you're asking for is an analysis of the LAO report, but the Governor's January budget might be out by the time we have our meeting.
You're right. I think it's supposed to be out January 10th.
Thank you. So with your permission, I think it'd be more important to provide you an overview of the January 10th budget as opposed to the LAO.
You're absolutely right.
That works for me.
Could I just interject? It'd be nice to get a copy of that for each of the board members if we haven't already
Before?
received one. Because it's what the LAO has to say is just very insightful, and they can talk about trend lines and things like that and issues in the future.
Absolutely.
Thank you.
Okay. So if I may combine the two, your motion is to provide a copy of the LAA report that we can get to the members via email by the close of business today, and then be prepared to report out on the governor's budget at our January 23rd meeting.
That works for me.
I had a comment.
Please.
I think the strong election of all of us is something we can be proud of, and I think part of Malia's great success is that the public really appreciated her work as our chair. I just want to thank our staff who's come aboard and made us all look good. I'm talking about Lisa and Peter and Dustin, who I think Dustin and Peter just joined us this year, and I think we're much more effective, and with the leadership of our new director, we're at an all-time high, and we should enjoy that. Thank you.
Thank you.
All right, at this point, I just want to acknowledge that usually we have the Department of Finance come and present to us to talk about the financial snapshot for the state of California. So what we can do is we could just take up the item back in January or in the springtime, certainly, when there's just more substance to discuss for the financial snapshot of this, for the state of California. So the LAO is certainly welcomed, and the presentation is welcomed, but we will have a formal presentation from the Department of Finance to come in, if not January, possibly February. All right?
That's fine. That's
Okay, thank you. All right, so, motion, is a motion made? I can't recall.
I
Well, it was
believe-
modified, but I accepted the amendments.
Okay, so a
If you
motion,
captured it, I don't know if you were able to get that, but
Ms. Cicchetti, could you read the motion, and then we'll take a vote on it?
Motion that I have is, let's make sure I get it correct. The motion to provide a copy of the LAO report that we can get the members by email by the close of business, and to prepare a report to the, on the governor's budget at our January 23rd meeting,
Okay, great.
2023.
I'll second that motion.
So-
And the motion was made by Mr. Vasquez. I'll
Vasquez,
second that motion.
Okay.
And let's take public comment.
AT&T moderator, do we have anyone on the line who would like to make a public comment regarding this item?
Once again, if you have not already done so, press 1 then 0 to queue up for comment. We do have one in queue. We're going to Janine Kilroy. Please go ahead. Your line's open.
You know, and I apologize. I actually want to comment later in the agenda. I joined late, so I will punch in the request at that time. Thank you.
No problem. Okay. Seeing that there's no other public comment, let's call
Aye.
the roll.
Chair Cohen,
Aye.
Vice Chair Schaefer,
Aye.
Member Gaines,
Aye?
Member Vasquez,
aye?
Deputy Controller Epelike.
Aye.
The motion passes.
Unanimously, great, thank you very much.
Next item on the agenda is other administrative matters, Executive Director's Report, K1B, Operational Priorities. A report on the status of the operational priorities presented by Ms. Renati.
Good morning, Chair Cohen and honorable members. My name is Lisa Renati. I'm the Chief Deputy Director. Today, I'll report on some of the agency's operational priorities and projects. The first item is our workforce capacity. We continue to actively fill our vacancies using strategic recruitment approaches and leveraging the services of our service provider. Since last month, we have hired one new employee in our property tax department, and that person is new to state service. We have had multiple vacancies in active recruitment and hope to share news of additional hires in the coming months. The next item is in regard to the agency's strategic goal regarding workforce development. We continue to implement our workforce development and succession plan, which includes providing staff with practical hands-on experience and mentorship to assist with the knowledge transfer, and ensuring our new staff and managers have the tools needed to perform and grow in their roles successfully. Members, this concludes my report on the agency's day-to-day operational priorities. If you have any questions, I would be happy to answer them.
I have no questions. Anyone? Nope. On this side, no. Mr. Vasquez?
Just a quick thank you, because I know you, especially for you and your staff, when we started this whole Prop 19, the implementation, that was a heavy lift. So I just wanted to recognize your staff and thank you.
You're welcome.
Thank you. Okay.
The next item on the agenda is Administrative Matters, Executive Director's Report, K1C, Proposition 19 Implementation Project. Report on the status of the agency's Proposition 19 Implementation Project, presented by Ms. Renati.
Hello again, I'm Lisa Renati, Chief Deputy Director, and I will provide an update on our Prop 19 implementation project. 2 years ago, our staff embarked on a detailed Prop 19 implementation plan to implement the changes in the law as a result of Prop 19. A high-level implementation plan is attached to today's agenda, highlighting 7 separate work categories, activities, and significant phases through the end of 2022. I'm happy to report that the status of BOE's implementation of Prop 19 is green, meaning no issues to report. As of yesterday, December 12th, our Prop 19 webpage has received 418,085 unique external page views since we launched this page in November 2020. This includes an additional 10,592 unique external page views since our last board meeting. This concludes my presentation on this topic. I'm available to answer any questions.
Thank you for your presentation. Mr. Vasquez?
Just a quick thank you again on the language. I understand now that we're up and running in Spanish and in Chinese, and I was wondering if we were going to be able to include any other language.
I don't want to steal Ms. Thompson's thunder, so
Oh,
I'll let her talk about that.
I'll wait.
Yes.
Thank you.
Great. Mr. Gaines, Mr. Schaefer? No?
No comments, thank you.
Thank you, no
Thank you.
comment.
Yep.
I'm going to go out to the AT&T moderator to see if we have anyone on the, AT&T moderator, do we have anyone on the line who'd like to make a public comment regarding this item?
And once again, for comment, please press 10 at this time. An operator will gather your name and place you in queue. When you hear your name called, you may proceed with your comment. Please press 10 for comment. And we go back now to Janine Kilroy. Please go ahead.
Hi, thank you for the opportunity to comment. I had visited in person at the last meeting, which was a few months back. Unfortunately, I wasn't able to make it up from the peninsula today to be in person. But my comment is around Proposition 19. Just want to bring up a couple of points and ask that the board consider a campaign to educate people. I continue to see people speaking about Proposition 19 on Nextdoor, for example. There is a ton of confusion and misunderstanding where people think, oh, my family property is in a trust. There'll be no impact. And I think there are a lot of people that will be harmed. Another comment that came up was an example of a lady's husband who passed away. They have a rental property. It's in an LLC. Those people, those multiple families in that property will be displaced. The property tax increase will not cash flow. So I think there is a lot of pain. I actually went into my local office, spoke with somebody at the reception desk, and was startled that this person, granted they're not an assessor, had no clue about this part of Proposition 19. So my point is I think there's still a lot of uneducated people that have no idea this massive change, and it will really negatively impact all of the rental properties owned by mom and pops. And I think it would be wonderful if people at least were armed with current knowledge, because when someone passes away, this is an incredibly difficult kind of surprise blow, if you will. And that is it. Thank you very much.
Thank you, caller. We appreciate that feedback, and we'll take action on it. Are there any others, public speakers?
Madam Chair, we have no other respondents in queue.
All right, thank you.
Thank you.
Could I just add a comment,
I'm sorry, who has a comment?
if I could?
Yes, please, Mr.
Yeah,
Gaines.
thank you. I appreciate what our constituents said in terms of further outreach with regards to Prop 19. And I thought that was a good idea in terms of taking a look at Nextdoor or other mechanisms for outreach for folks, just so that we can broaden the message to more of our constituents. So I think we're following up on that. Is that right? Okay, good. Thank you.
Okay, thank you. Is there action on this item?
No, there isn't unless you guys want to, does any sort of motion based on the caller?
I don't think there's a need to take a motion on this item. Want to acknowledge the controller, she's joined us. At this moment, let's depart on this section of the agenda and go back to the top of the agenda.
Perfect.
So we can dispense of the items.
Okay.
Okay.
All righty. We'll begin with the top of the agenda.
Yes,
Our
please.
first order of business that was supposed to be today was our oral hearings. Item B.
Yes.
Property tax hearings. Contribution disclosure forms are required pursuant to Government Code Section 15626. Board Proceedings has received contribution disclosure forms for this morning's hearing from all the parties, agents, and participants. No disqualifying contributions were disclosed. All parties, agents, and participants were listed on the memorandum provided to your office. As this case is an adjudicatory matter, the board hearing of this case is subject to the prohibition on ex parte communications, with any violations of the prohibition being disclosed for the record. This is a constitutional function. The oral hearing procedures are as follows. The oral hearing will be announced in the order presented on the agenda. When I call your case to be heard, please be ready to unmute and turn on your camera as requested. The appeals attorney assigned to the case will introduce your case, stating the issues for the board's consideration within the oral hearing and noting any agreement of the parties. After the appeals attorney has completed the introduction, the parties will then be asked to introduce themselves and their affiliation with the taxpayer or the State Assessed Property Division for the record. For this morning's board meeting, there is only one case. The matter is B1, Property Tax Appeals Hearing, Petition for Reassessment of Unitary Value, Southern California Edison Company, 0148, SAU 22-006. This is a hearing conducted under Section 40 of the Revenue and Taxation Code. If any witnesses are called, I will place them under oath. After hearing the arguments of the agency and the representatives and considering the evidence, the board may vote to adopt the staff recommendation, reject the staff recommendation, or make their own determination to resolve the issues under consideration at the hearing. The petitioner and the respondent, the department, will each have 60 minutes to make their initial presentation. Then the petitioner will have 15 minutes on rebuttal, followed by any questions from the members. This matter will be introduced by the appeals attorney, Ms. Yim, who will provide a brief introduction of the case. Ms. Yim?
Yes, good morning, Chair Cohen and honorable members of the board. I'm Sonia Yim, the appeals attorney for the State Board of Equalization. In the case before you, the petitioner is Southern California Edison Company, a public utility operating in Southern, Coastal, and Central California. The 2022 board-adopted unitary value, as well as SAPD and the appeals attorney's recommendation of value, is $34,274,700,000. Petitioner is requesting a unitary value of $26,996,100,000 for purposes of this petition. Accordingly, this appeal is subject to Revenue and Taxation Code Section 40, as the amount in controversy exceeds $500,000 in tax. Thus, after the board's decision on this petition today, the appeals attorney will prepare a decision to memorialize the board's action in early 2023. The petitioner has raised 5 primary issues with its 2022 board-adopted unitary value, which was based on the January 1st, 2022 lien date. As such, the parties will present the following 5 primary issues within this petition. First, whether petitioner has shown that respondent has failed to reconcile the historical cost less depreciation, or HCLD, value indicator, and the capitalized earning ability, or CEA, indicator of value. Second, whether the petitioner has shown that respondent erred in placing 75% reliance on the HCLD value indicator and the 25% reliance on the CEA indicator of value. Third, whether petitioner has shown that respondent must adjust the board-adopted value for petitioner's liabilities for the 2017 and 2018 wildfires and mudslides. Fourth, whether petitioner has shown that respondent improperly assessed $1.6 billion of wildfire mitigation capital expenditures. And fifth, whether petitioner has shown that respondent erred in its treatment of wildfire insurance fund related contributions. Petitioner has the burden of proof to show that the 2022 board adopted assessment is incorrect or illegal. The parties are present and they're ready to present their cases before the board. This concludes the appeals attorney's opening remarks. I'll turn it over to Chair Cohen to proceed to hear this petition.
Thank you very much. Colleagues, just checking in to see if there's any questions or comments. No? All right. Let's continue.
The petitioner and the respondent, welcome to the Board of Equalization. Petitioner, please unmute your microphones, introduce yourselves, and state your affiliation with the taxpayer for the record.
Good morning. My name is Marty DeKessian, and my firm DeKessian Law represents Southern California Edison.
Good morning, Mr. DeKessian.
Good morning, Madam Chair, members of the board. My name is Charles Mall. I'm with the law firm of McDermott, Will & Emery, and I also represent the taxpayer.
Thank you. Good morning to you both. All right, you may begin.
Thank you. So, Madam Chair and members of the board, good morning to you all. Happy holidays to you all. I wanted to also acknowledge that with me today, in addition to my co-counsel, Mr. Mall, are Andrea Wood, VP of Tax with Edison International, Carl Matthews, Principal Manager with Southern California Edison, and Mr. David Lee, Tax Manager with Southern California Edison. So this is the third year in a row that we appear before you regarding SAPD's excessive valuation of Edison's assets and the board's adoption of the same. Our issues all relate, as you know, to the ongoing wildfire crisis and its impact on the value of my client's property. You've heard our arguments before, and what we present today will be similar to what we've presented in past years. I know you're also aware of the pending litigation in Orange County Superior Court covering the same issues. So what I'm trying to say is I'll be as succinct as I can with my comments, understanding full well that the board is familiar with these issues. So Ms. Yim's introduction was just fine, although we presented the issues in a little bit of a different package when we were asked to provide the board hearing statement. So we're not going to exactly follow the issues the way that Ms. Yim outlined, but we'll cover all of those issues. The first issue here, members of the board, is the approach to value. What's the proper approach to value? And the income approach is the preferred approach here, not historical cost or net book value, which is the approach the staff is using. Now, why do we say that? We say that because the board's own regulation says that income is the preferred approach. Property Tax Rule 8 says that the income approach is the preferred approach for the appraisal of improved real properties when reliable sales data are not available and the cost approaches are unreliable because the reproducible property has suffered considerable physical depreciation, functional obsolescence or economic obsolescence, is a substantial over or under improvement, or is subject to legal restrictions on income that are unrelated to cost. What staff did here is weight historical costs 75% and the income approach 25%. That's improper. Why? Because we meet several of the requirements for using the income approach under Rule 8 as the preferred approach. That's because we have considerable physical depreciation here, which Rule 8 identifies. We have largely older assets. Yes, we have many newer assets, but we have largely older assets. We are suffering from economic obsolescence, which is also referred to in some appraisal manuals as external obsolescence. We have it here with the wildfire-related expenses, our adverse insurance situation, inverse condemnation and strict liability, the operational uncertainty under Assembly Bill 1054, and the overall economic environment for investor-owned utilities. And we also have legal restrictions on income unrelated to cost, which is another criteria under Rule 8. We have it here. The entire regulatory framework limits my client's ability to earn a return on these assets. So what are the problems with using the HCLD approach? The appraisal handbook of an organization called WSATA, which is the Western States Association of Tax Administrators, which the SAPD cited in its February and March presentations to you as something that they follow. The WSATA manual says the following regarding the historical cost approach. Quote, the most important point to bear in mind is that regulatory agencies like CPUC are in the business of setting rates based on a complex set of economic, legal, and human factors. The agencies do not determine or even estimate any value any more than tax assessment agencies set rates. CPUC does what they do for regulatory purposes. This board's charge is to assess this property at full cash value. We know that the CPUC decisions on a risk premium, on prudency, on allowed expenses, and ability to earn are made on a variety of factors that don't relate to fair market value, which is this board's charge. The CPUC is balancing the interests of shareholders, the ratepayers, and other concerns relating to their constituents. This is not a reflection of fair market value. Yet staff says it relied on CPUC decisions as, quote, the best sources to quantify adjustments. This is in the February 23rd meeting. So not just as background, but they use the CPUC decisions, which are not indicia of fair market value, as the best sources to quantify their adjustments. That's improper. and they defer to the regulators entirely. That's improper. This board does not defer to anybody when it comes to setting fair market value of the property. And the other thing to keep in mind is historical cost only represents the opportunity to earn a return in the future. There's no guarantee that just because a capital expenditure has been made that my client's going to have the opportunity to earn that future return. That's up to the CPUC through the rate-making process and through the rate case process that takes place once every 3 years. So the market, any willing buyer would have to account for both risk and delay in payment if you're a prospective purchaser of these assets. So another point that I made last year, but I think deserves underscoring, is that SAPD and appeals, they both gloss over this, but the approach that they've been using with this 75-25 weighting has been the same approach since 2006. 2006, to put it in perspective, the iPhone did not exist in 2006. Okay, so yet we're using the same weighting despite the variety of economic, technological, and climate changes that have taken place since then, the wildfire crisis hitting a fever pitch in the past few years. We're still using a 2006 formula. Why? There's no justification for it. There's no basis for it. Things have changed a lot since 2006. I think we can all agree. So staff's unwillingness to change the weighting and, this idea that, we're being consistent, that's not really, I mean, in some situations that's praiseworthy, not in this situation. A lot of time has passed. We've shown year after year the changes that have taken place, the burden that my client has been operating under, and that these assets, the impairment that these assets have faced, and yet no change to the weighting that's been in place since 2006. That's wrong. The bottom line, why the income approach? It's quite simple. The market cares about income. No prudent buyer would ever pay more for an income-producing property than the income it generates. That is what drives the market value for these assets. The market does not care about net book value, which is what historical cost is, unless it is reflective of the earning power of the property. That's why net book value has been used, because generally it's reflective of the earning power of the property. In this case, it's not. The market cares about how much income these assets can generate. So staff's overwhelming reliance on net book value shows that its valuation is untethered from reality. The second point, major point I wanted to make, has to do with the reconciliation of the value indicators. The weighting wouldn't be as much of an issue for us if the value indicators were close to each other. They're totally out of alignment. They're $8.5 billion apart. Well-established appraisal methodology requires that SAPD's valuation have reconciled these substantial differences. They didn't do it. Have we met our burden of proof? Absolutely. If they're $8.5 billion apart, and we have no cogent reason why that is. We can talk about regulatory lag, but that's just a catchphrase they've used. They haven't really quantified anything. There's no explanation for an $8.5 billion value chasm. And so when you have that kind of a difference and you compound that by weighting the higher value 75%, you can see how everything is totally out of whack. Now, it's not an issue that appraisal work, I'm not saying that appraisal work needs to be an exact science. We all know that it's not. We all know that there's a lot of judgment that goes into appraisal, that the value is not one value, but a range of values. But and significant differences may occur. The handbooks do say that, but these are more than significant differences. The value indicators need to at least be in the same ballpark. They have to at least be relatively close to one another. Because if they're not, then that raises red flags about the validity of the approach that the appraiser took. You can't, they're all supposed to end up roughly the same. Not exactly the same, but roughly the same. So any independent appraiser will tell you that. So the $8.5 billion is not just, we can't just chalk it up to, oh, well, there could be differences and value indicators may vary. That's not a fair characterization of what's happening here. One approach here is 30% higher than the other. The cost approach is 30% higher than the income approach. Your own regulation, Property Tax Rule 2, for purposes of the purchase price presumption, which I would admit, but defines a significant deviation as 5%. We're at 30% here. Where's the reconciliation? Where's the explanation? Reconciliation means explaining. Reconciliation means comparing. Reconciliation means analyzing and understanding and justifying the differences between the two approaches. That's what the assessor's handbook calls for. That hasn't happened here. So why is there the difference? We maintain that it's obsolescence. Why do we say that? We say that it's external obsolescence. We didn't just come up with that. That came from your board's own handbook. Assessor's handbook suggests that a capitalized earning ability indicator, which is much lower than HCLD, may indicate that obsolescence exists in the property to such an extent that the owner may not earn the rate of return allowed by the regulatory agency. This is the same page of the assessor's handbook that staff cited in its February 23rd presentation to the board. Why don't they quote the board the whole thing? Again, differences may vary, this is true, but variances of this magnitude, we are likely dealing with obsolescence here, but staff has completely dismissed that as a possibility, even though your own handbook says that this is likely what's going on. Without the reconciliation, the valuation is arbitrary. We have offered SAPD several solutions to correct this. They can either make the specific adjustments that we requested, they can make a single obsolescence adjustment, they can use the income approach entirely, or at the very least change the weighting to arrive at a reasonable valuation. They've refused to implement any of these solutions, and your board has ratified this for 2 years in a row now. Okay, so now let's move to the capital expenditures. In the utility context, HCLD is driven by the CPUC's rate base because that's what measures the earning power of the utility. It's not just for any random reason, but that's what the market is trying to understand and capture and what the market pays attention to. So rate base is what is used to compute the allowable return for investor-owned utilities. Southern California Edison does not get to earn a return on these wildfire mitigation capital expenditures. It does not earn a return on these expenditures. That is undisputed. And as for return of, do you remember this distinction last year? Staff was saying, well, we took it out for return on. We didn't take it out for return of because they're still, the assets still belong to them. That's not the standard for how return of is measured in a regulatory context. The term return of in a regulatory context is a term of art that references depreciation. So if you're allowed to depreciate the assets, you're considered to have a return of those assets. We don't get to depreciate these assets. They're not ours. So there's no return of the property. There's no return on the property. All this needs to be taken out of rate base. Again, this does not reflect the earning power of these assets because they can't earn on them. They're precluded legally from earning on them. So in any event, we can move on. The capital expenditures need to come out fully from the HCLD value indicator. Okay. Obsolescence we discussed. We believe this dramatic difference is obsolescence. Again, this is supported by the board's own guidance. So I think we can move on now to the insurance issue. This was an issue of contention the last few years. There were some very insightful comments and insightful discussion by the board, but no adjustment was made. We request that you make an adjustment here for the initial contribution. SAPD, bottom line, should have allowed Edison to annualize its initial $2.4 billion contribution to the Wildfire Insurance Fund, just as the Assessor's Handbook directs. This is a continuing theme. The Assessor's Handbook is directing these adjustments be made. The Assessor's Handbook is providing evidence of obsolescence, and staff's not following it. This isn't a fair, reasonable appraisal, and it's not consistent with this board's own appraisal practice. Now, the SAPD says that, well, this expense was made prior to the lien date, so we don't need to account for it. The problem is, of course you do. Under the direct capitalization approach, it's true you're looking at current year income and current year expenses. However, there's an exception when you have prepaid expenses. the assessor's handbook, which specifically calls out prepaid insurance as an example of a prepaid expense. The exception is that if you have a significant prepaid expense in a prior year, you're supposed to annualize that so that the values are stabilized year over year, so that you don't have a high value in one year and an exceedingly low value in the other. And that's what happened here. There's no question that this is insurance. I'm not sure where staff stands on it this year. Last year they vacillated a little bit. First they said it wasn't insurance, then they said it was insurance, then they said, well, even if it is insurance, so I'm not sure where they are. They'll tell you about that. Staff also incorrectly says that we're amortizing these expenses and we're asking this to be treated like depreciation of a capital asset. That's not what's happening here. What's happening here is we're asking for this asset to be annualized, consistent with the assessor's handbook, just as prepaid insurance, the example that they've used. SAPD also says that we haven't established that this insurance expense is recurring. That makes no sense. This is insurance. Yeah, it's true that an initial contribution exactly identical to this one is not on the horizon, but at the end of the day, it's insurance. You can make that argument about any expense. Every expense is a snowflake. There will never be another expense just like this one. The insurance contribution is prepaid insurance. It's a funding of the wildfire insurance fund that allowed Edison to have access to this layer of insurance. And there are a lot of reasons for that we've discussed in prior years in terms of the market for insurance in this incredible environment that we're in. So we don't need to have an exact duplicate of this initial contribution for a reasonably prudent business person to take this into account. And that's what this comes down to. A willing buyer would certainly take this prepaid insurance into account, because when comparing two companies, one that has made the payment and one that is not, a willing buyer would pay more for the company that made the payment, because the buyer would benefit from greater future cash flows, which represents an intangible asset that should be excluded from income from taxation in any event. So, which we'll get to in a moment. But the bottom line is that these insurance expenses need to be taken out. This is 3 years in a row now where this isn't happening, and it needs to. So the wildfire claims liabilities, let's talk about that for a second. So Edison is entitled to a reduction for the 2017-2018 wildfire claims liabilities totaling $3.6 billion. Staff says these are past expenses. They're contrary to Rule 8, which seeks to capture a future income stream. They're not past expenses. The claims liabilities are going to come up in the coming years. The accrual was made in prior years, but the actual expense is going to happen in future years. So again, any willing buyer would have to take that into account in purchasing these assets. So, not to mention the prospect of claims and settlements increasing as there are more wildfires to be paid in the future. The current estimate of liabilities that we have that have been accrued over a 4-year period are expected to be paid over a five-year period exceeds $5 billion. This is the amount after insurance recoveries. The claims expenses are also should be considered as recurring. I don't think anybody in the scientific community would agree that wildfire expenses and related claims will be non-recurring. That's SAPD living in a vacuum. That's not the real world. A reasonably prudent business person would certainly factor in the cost of these continued claims in purchasing these assets. I don't know how many different ways to say it. So you're going to buy an investor. Let's put yourself in the position of a prospective buyer. You're going to buy an investor-owned public utility in a drought-stricken region impacted by climate change. What would you tell the seller if it stated that the wildfires and related claims are one-offs and that they're not going to happen again, or that we don't think they're going to happen again? All you need to know is if you've ever tried buying insurance in a wildfire area, how expensive insurance is, and it's not even available in many cases. SAPD has failed to consider the enormous risk that a willing buyer would perceive in the purchase of a California utility that employs the inverse condemnation standard. That means strict liability. That means Edison doesn't even need to be negligent in the context of these claims. Strict liability. Couple that with a commission, a public utilities commission that has a history of denying recovery. That is enormous risk that a willing buyer would be undertaking. So again, if the utility's equipment played a role in the ignition of the fire, then the utility is responsible regardless of whether they were negligent. This is the circumstance that a willing buyer would be walking into. Recovery of claims expenses is a separate issue. That's also fraught with risk to a potential buyer. That's because the CPUC has a long history of denying recovery of wildfire claims, and the new legal standard for recovery of those claims adds additional uncertainty as to whether recovery would be allowed for future claims. So, staff also says that public utility that these wildfire claims don't attach to the public utility property; they attach to the business as a going concern. But public utility property is heavily regulated, and it cannot be sold separate from the liabilities. That just can't happen. The CPUC would never allow it. So, in short, staff's position on these claims liabilities runs counter to established science, counter to business considerations, regulatory practice, and common sense. So these claims liability expenses need to be allowed. The next issue I wanted to touch upon is the issue of intangibles. What's an intangible? An intangible includes any license, permit, or other right granted by the government. So we made the argument earlier about capital expenditures needing to be excluded because our client cannot earn a return on these assets, on the capital expenditures that are being made in a regulatory context. That's one argument. Separate and apart from that, the first $1.6 billion of these wildfire mitigation capital expenditures effectively create an intangible asset that must be removed from the HCLD indicator of assessed value. These non-depreciable expenditures were a prerequisite to Edison receiving a favorable prudency standard in future proceedings for recovery of wildfire losses. Specifically, if you make these wildfire mitigation expenses and obtain an annual safety certificate, you are subject to a more favorable regulatory standard of review in determining whether you're going to be able to recover wildfire-related expenses. When you make an expenditure to gain a favorable, a privilege or a right or a favorable treatment according to a new favorable legal standard, that's an intangible. That's an intangible asset. The capital expenditures that Edison made also give Edison the legal right to cap its wildfire insurance fund reimbursement exposure. That's also really important. So these capital expenditures and the obtaining of an annual safety certificate give Edison these very important intangible rights, and they're intangible rights which are not subject to taxation and should be removed. Similarly, the insurance initial contribution creates an intangible asset that should be removed from the CEA indicator. First, it creates the right to greater future cash flows, because if you make an expense, a big lump sum expense in prior years, then you have greater cash flows in future years. That's an intangible right to receive those greater cash flows. Second, the making of that initial contribution gives Edison and the other investor-owned public utilities that made that initial contribution access to the wildfire insurance fund, which is also an important intangible right. It's also the right to participate in the wildfire insurance fund. That's important. These are intangibles. They need to be removed. So I think I'm getting ready to wrap up here. I will say this. We did preserve the issue of risk premium. We're not going to discuss it today. I'll just conclude with this. The board's charge here is to assess Edison's property based on fair market value, not based on what CPUC did, not based on, well, we've always done it this way. Rather, the board must do it based on what a willing buyer would pay for these assets. That's the ultimate test, what a willing buyer would pay. It's not enough, as staff said, to just monitor. We'll continue to monitor climate change and wildfire developments. That's not enough. That doesn't cut it. How much more time does staff need? How much more time does this board need to accept the new reality that we're in? That's this board's charge. Respectfully, SAPD hasn't done that. The board, in adopting SAPD's values, hasn't done that either, and that's why we are where we are. Instead of assessing Edison's value based on fair market value, assessing Edison's property, I should say, based on fair market value, we also believe the board has assessed Edison's unitary property in a non-uniform and unequal manner in violation of the California Constitution and the equal protection clauses of the California and the U.S. Constitutions. Specifically, the board has given the other investor-owned utilities a deduction for the wildfire initial contribution, and we haven't gotten anything. My client hasn't gotten anything. The others have gotten it, we haven't. And finally, the board has stuck with the 75-25 weighting arbitrarily in these past few years, despite a mountain of evidence regarding climate change and wildfires that compels a different approach. From our perspective, this is arbitrary and capricious in violation of the due process clauses of the California and U.S. constitutions. Bottom line, members of the board, these are income-producing assets and should be valued using an income approach. It's that simple. If this board were to value Edison's assets and property using the income approach, we probably wouldn't be here. But for some reason, staff's unwilling to alter its approach that goes back to 2006 and unwilling to allow us the straightforward, reasonable adjustments we requested and to which we're legally entitled. This is wrong and contrary to established appraisal standards. The board stated last year and in years past that these issues raised by Edison are worthy of continued study, subsequent analysis, subsequent examination. Since then, we've confirmed that these adjustments should be made. For all these reasons, we respectfully request that the petition be granted. Thank you.
Mr. DeCessian, thank you very much for your report. I think you raised some really interesting questions. We are going to have a spirited discussion, I'm sure. Let me look to my colleagues, see, does anyone have any questions or any follow-ups for Mr. DeCessian?
We could do it at the end.
We'll do it at the end.
SAPD
Do it at the end.
has
Fair
Yeah.
enough.
the
All right, let's hear
department.
the rebuttal.
We'll go to the State Assessed Properties Division for their presentation. Please unmute your microphones and introduce yourselves for the record.
Good morning, Chair Cohen. Thank you. My name is David Lujan with the Legal Department, representing SAPD. Today we also have Jack McCool, Daniel Jenkinson, as well as Michelle Cruz on behalf of SAPD.
Please continue.
Thank you. Before we get into the specific issues raised in this year's petition, we'd like to provide some context by way of background. First off, this is the third year that petitioner is raising the same issues. The board rejected the petition in the prior 2 years. As petitioner has presented essentially nothing new, the board should reject this year's petition as well. Second, petitioner added $4.6 billion in new property this year, but requests a $4.3 billion reduction in value from last year. Third, petitioner again cites the risk of catastrophic wildfires as a reason for its value reduction request. We emphasize again, however, as in previous years, the PUC determined no adjustment to petitioner's rate of return for wildfire risk was warranted. However, despite this, staff again made an obsolescence adjustment of approximately $1.9 billion to account for this risk. We would also note that catastrophic wildfires in California have decreased in the last 2 years, and that as far as staff is aware, petitioner has not, indeed no utility has used the AB 1054 created wildfire fund. In fact, petitioner itself recognizes this decline, stating in its latest 10K that SCE expects that any losses incurred in connection with 2019-2020 wildfires will be covered by insurance, and expect that any such losses after insurance recoveries will not be material. This decline in risk is also recognized by the increase in petitioner's credit rating and outlook. Finally, we would like to briefly describe the 4 specific adjustments to petitioner's 2022 unitary value related to wildfires. First, petitioner requested and staff applied a 0.85% risk premium to the capitalization rate used to calculate the CEA indicator, which resulted in a reduction to the overall unitary value of $416 million. Staff also made an obsolescence adjustment to the HCLD indicator, resulting from the addition of the 0.85% risk premium to the capitalization rate, which resulted in a reduction to the overall unitary value of $1.528 billion. Staff made an adjustment to account for SCE's inability to earn an equity return on the $1.6 billion in wildfire mitigation capital expenditures because AB 1054 precludes SCE from earning only an equity return on these capital expenditures. This resulted in a reduction to the overall unitary value of $513 million. Finally, staff calculated an adjustment to account for the 8 remaining $95 million payments into the wildfire fund as required by AB 1054. This leads to a reduction to overall unitary value of $136 million. Taken together, these wildfire-related adjustments combine to reduce petitioner's unitary value by $2.593 billion. With respect to issues 1 and 2, the proper weighting and reconciliation, in doing its assessment, SAPD took all relevant information into account and appropriately computed and reconciled both an HCLD and an income or capitalized earning ability, CEA, indicator of value. Here, pursuant to the property tax rules, HCLD is the most reliable value method because the HCLD indicator of value begins with the actual assets on which PUC allows petitioner to earn a return. Thus, staff weight it more heavily than the income indicator. Petitioner criticizes the weighting of the HCLD and CEA indicators because the difference between the two values. They simply conclude, however, without evidence, that this difference is obsolescence due to wildfire risk, and that the CEA must be given more weight. But there is nothing that makes it necessarily true that any difference between HCLD and CEA is always obsolescence. Assessor's Handbook 502 recognizes this. It says a difference might indicate that HCLD is too high. It is, of course, entirely possible that the CEA is too low. Additionally, to the extent that a difference between CEA and HCLD might be due to obsolescence, as previously explained, an adjustment has been made for obsolescence by allowing an increase to petitioner's rate of return. Thus, staff believes that all appropriate obsolescence adjustments for general wildfire risks have been made. If petitioner believes that a greater weighting of the CEA indicator is necessary, the burden of proof is on petitioner to present the specific reasons why. In the future, if they are willing to present such evidence, we're happy to take a look at it to see if additional adjustments should be made. Regarding 2017-2018 wildfire liability, Issue 3, petitioner requests a $1.635 billion reduction to its board-adopted value for its lawsuit liabilities accrued on its books. This liability, however, is not deductible because it is not an ordinary expense, one that would be expected to be paid to maintain or operate the property. Rather, this is liability that accrues from lawsuit settlements from the 2017-2018 wildfires and mudslide, some of which may have been started by petitioner's equipment and damaged property owned by others. This is important because it means that these liabilities may affect the price someone would pay for the entire company, i.e. the entire business, sometimes referred to as going concern, but it does not affect the value of the taxable property, and what is being appraised is the taxable property. That $1.635 billion is therefore a liability that may reduce the price a prospective purchaser might be willing to pay, but it does not affect the price a prospective purchaser would pay for the taxable property, because it does not affect the property's ability to be used to generate income. With regards to Issue 4, the $1.6 billion wildfire mitigation capital, AB 1054 requires petitioners to spend about $1.6 billion on wildfire mitigation capital expenditures, for which they are allowed to earn no equity return. The statutes are clear. They prohibit petitioner from earning a return on that investment, which is reflected in the equity portion of their rate base. They do not prohibit earning a return of its investment, which is reflected in its recovery of amounts spent, and staff made an adjustment for that. Staff removed the equity portion of their rate base that AB 1054 does not allow. It is also important to take a step back and see the big picture, exactly what petitioner is asking the board to do. Petitioner states that this property has zero value since it is prohibited from earning an equity return on its cost, and that no investor would purchase it. This ignores the fact that the property contributes to earnings and has value and may be sold as part of the system. Simply put, it spent $1.6 billion on property in the last 2 years, and are now asking the board to assess it at zero because they are not allowed to earn an equity return on that investment, ignoring the fact that they are getting their money back and the property is contributing to earnings. With respect to Issue 5, the AB 1054 Wildfire Fund initial contribution, petitioner's initial contribution of $2.4 billion to the Wildfire Fund as required by AB 1054 is not considered an operating expense under basic appraisal theory because it is not an expected recurring cash expense. Instead, it is an amortized past accounting expense that need not be paid again. Petitioner itself identifies the initial $2.4 billion contribution as a non-core item in its annual report. Non-core items includes income or loss from discontinued operations and income or loss from significant discrete items that management does not consider representative of ongoing earnings, such as income and expense related changes to law. This is a perfect description for this payment. In essence, petitioner acknowledges in its annual report that this amount will not be paid again, but is asking the board to treat it like it is. Although petitioner clearly admits this is a non-cash, extraordinary, amortized accounting expense, petitioner points to language in Assessor's Handbook 502 regarding prepaid insurance as supposedly supporting its position that accounting expenses can be deducted. However, the Assessor's Handbook refers to anticipated, recurring, and annual prepaid amounts that represent future cash flows. They say that certain expenditures are annualized when using a direct capitalization model. The specific example given is of insurance prepaid for 3 years. It allows annualization of a 3-year prepaid insurance amount because there is an assumption that after the initial 3 years, there must be another outlay of cash that covers the next 3 years and so on. In contrast, it is undisputed that this single one-time AB 1054 initial contribution made back in 2019 does not reoccur. Therefore, unlike the Assessor's Handbook example, where you get a distortion of capitalizable income if you do not annualize the prepaid insurance, here you do get a distortion of income if you do annualize the initial contribution. Because it will never be paid again, it is improper to allow it as an expense and then project that out into perpetuity as is done in the direct capitalization model. In conclusion, SAPD has recommended all appropriate adjustments for petitioners' general and specific reductions related to wildfires, consistent with relevant authorities and petitioners' own public statements. As to general wildfire risk, petitioner and the PUC fully agrees that AB 1054 mitigated much of their risk, and even state in their 10K that they expect losses after insurance recoveries for future fires will not be material. However, staff allowed an increase in petitioner's rate of return that CPUC did not allow, resulting in approximately a $1.9 billion reduction. Petitioner's request for a reduction in value due to wildfire lawsuit liabilities is not appropriate because those lawsuits do not cause a reduction in value to its taxable property. CPUC and petitioner both acknowledge that petitioner may earn a return of its AB 1054 wildfire mitigation capital expenditures. And finally, petitioner admits in its public documents that its AB 1054 initial contribution is a non-core item, a one-time payment in the past that will never need to be paid again. Yet it insists that a prospective purchaser would still consider that they would have to pay it. Thus, making any of these adjustments would not only require violating general accepted appraisal practices, it would require ignoring petitioner's own statements. For these reasons, we recommend denying the petition on all issues. Thank you.
Thank you very much.
We ask that you hold your questions until after the rebuttal for Southern California Edison.
All right.
Mr. DeCasian, you now have 15 minutes for your rebuttal.
Thank you. So, as usual, there's a lot to unpack. I'll do the best that I can here. In terms of, let's take them in the order in which staff discussed them. The increased assets, just because you have an addition of assets, that doesn't always correlate to an increase in value. We saw that several years ago when the San Onofre plant was deactivated and decommissioned and those assets were retired. That did not result in a decrease in value for that year, and that's because of the way that these public utilities earn income. It's their HCLD, net book value, measures earning power, and so does the income approach. And so an asset that may be placed in service doesn't necessarily on day one reflect value. That doesn't mean that the asset's being exempted in some way. It's just the way that these value indicators are being used. That's point number one. Catastrophic wildfires have decreased. Okay, maybe there's been a dip in a few years. Is staff prepared to say that climate change doesn't exist, that these wildfires aren't going to recur? Is staff prepared to contradict the scientific community? Let's hear it if that's what their argument is. But, you know, bring it on, because I think that is not, that's not a reasonable point to make. Okay, in terms of the specific adjustments, how did staff perform its reconciliation? We just flatly heard that they reconciled this 30% difference, this $8.5 billion. I didn't hear any detail on how it was reconciled. Why didn't we hear it? Because it didn't happen. There was no reconciliation. So it's their appraisal. They can't foist this on us. It's their appraisal. They didn't perform the reconciliation. The appraisal is defective. The obsolescence point, it's not us that's saying it, it's your own handbook that's saying it, and your own handbook says, yes, that not every difference is could be due to obsolescence. It may be obsolescence, but significant differences like this one are likely due to obsolescence. But staff didn't pursue that. They never pursued that. They just sort of left the $8.5 billion value difference just sort of hanging out there. Again, this is their appraisal. They need to step forward and say, why the $8.5 billion difference? They believe there's regulatory lag. Where's their computation of regulatory lag? Let's hear it. It's not on us. They're the ones asserting that as a defense for this $8.5 billion difference. So it's up to them to advance evidence to prove that. Just because the overall burden of proof is on us doesn't mean that their ability, that they're raising affirmative defenses, that puts the onus on them. If they're making a statement, they need to back it up. We don't need to disprove a statement that they're making. We don't need to prove a negative. The intangibles, no response. Crickets on the intangibles. We made the point on intangibles. We didn't hear anything from them. Why? Maybe they have a response. Maybe we'll hear it later, but nothing so far. I want to turn now to Ms. Andrea Wood to address the core, non-core item issue. Ms. Wood, are you there?
Yes, I'm here. Yeah, I would like to address that, because to say that upfront contribution could never occur again, I believe is just incorrect. We don't know. The fund was sized to support liabilities for the three major utilities, and it only takes one giant catastrophic fire in order to deplete the fund. So, you know, depending on what happens in the future, we would know whether or not we would need to continue to make contributions. I don't think that's as certain as was depicted. A one-time, you know, again, it's not a one-time payment. You don't know that for sure. The reflection of it as non-core in the financial statements is really that term core versus non-core, you know, that's not a general accepted accounting principle. That's something that we use, and other companies do too, to allow analysts to try to estimate what the revenues are going to be for the company. So, for example, O&M expenses like vegetation management, those are recoverable from ratepayers, and so they go into our rates. So that's core. Those are core expenses. This is non-core because it's not recoverable. We're not allowed to recover it in our rates. And so the analysts would know not to use it in trying to estimate future revenues. So I don't think you should read that much into the fact that it's reported as non-core in our financial statements.
Thank you, Ms. Wood.
Can I talk a little bit about the claims? Because I kind of want to hit home that, you know, we began to make accruals for wildfire claims in 2018, and this was right after the big fires that occurred in 17 and 18. That's the Thomas and the Woolsey fires. But we've continued to make accruals every year since then. As a matter of fact, we've accrued we have identified almost $8 billion in liabilities. That's before insurance. I think we had $2 billion of insurance, so you know over $6 billion of liabilities that have been accrued consistently in 2018, 19, 20, 21, and 22. So to say that's non-recurring, again, is I don't think that's accurate. And if you say, which we've heard from the staff before, but well, you can't pay attention to accruals because that's not cash. Well, we've been making payments under these liabilities We started making payments in 2019, made substantial payments in 2020, 2021, and 2022. And we're going to continue to make payments in 2023. So again, it's not that it's non-recurring. I know we've talked about the Woolsey and the Thomas fires, but since then we had the the Saddle Ridge fire in 2019, the Bobcat fire in 2020, and then this year we've had the Coastal and the Fairview fires. So again, to say it's non-recurring just doesn't ring true.
Thank you, Ms. Wood. Did you want to add anything else? Any of the other items?
No, I'm good for now. Thank you.
So picking up on the theme of the claims. So again, the claims, a willing buyer would certainly consider the prospect of having to pay out claims in purchasing these assets. And, last year staff brought up some example about some truck getting in an accident and tort liability. That's not what we have here. These assets are regulated. So you can't just pick up and sell these assets without accounting for the liabilities. The CPUC simply will not allow that to happen. So anyone buying these assets is going to have to take on the liabilities. So they can't be separated. And any willing buyer, any prudent buyer, any reasonable buyer would have to take these claims into account. Could you look a willing buyer in the eye, members of the board, and say these claims, don't worry about it, it's not going to happen again. This wildfire crisis, it's blowing over. Don't worry about it. And even if it's ongoing, you're not going to need to pay on these claims. That would be a total prevarication. Everybody knows that. Everybody knows that these wildfire claims are here to stay. It's going to be part of the new normal under a strict liability standard, especially when the utility doesn't even need to be negligent. Their equipment needs to have played a significant role in the cause of the fire, even if somebody else was at fault. Strict liability, that's what inverse condemnation means. So the claims are really, really important. And so I echo Ms. Wood's comments. In terms of the capital expenditures, let's not play this game, right? We're not asking for the assets to be exempt. What we're asking for is if we were going to use the historical cost approach, let's do it properly. Let's do it the right way. If we can't earn on these assets, they need to be taken out. That's what we're asking for. We're not asking for the asset to be exempt. If we were asking for the asset to be exempt, why did staff exclude the equity portion of it? Are they giving us an exemption? Of course not. Of course they're not. We're just asking them to take it out fully. Did staff give us a partial exemption because they took out the, no. Because that's what HCLD requires. HCLD is there to measure the earning power of the utility. If you can't earn on it, it needs to be taken out. And as we've explained, and I haven't heard any rebuttal from staff on this point, we don't recover the assets. We don't get depreciation on them. There's no return of the assets in a regulatory environment. Now, if staff wants to use another approach to value, if they want to use reproduction cost, replacement cost, or some other cost approach, then maybe we can take what they're saying into account. But as long as you're in the world of historical cost, this is the approach you have to take. And then finally, the insurance, I can't tell you, you can't dismiss the assessor's handbook as supposedly applying. This is what it says. Cash flow basis. Okay, in direct capitalization, this concept is adjusted slightly to annualize certain expenditures. For example, if an insurance premium is prepaid for a number of years, a prorated annual amount would be used as annualized expense. It's not me. It's your own handbook. They need to at least follow this board's own guidance, and they can't dispose of it or dismiss it as supposedly applying when it's squarely on point. These are adjustments that need to be made. They're reasonable adjustments that we're seeking. Mr. Mull, do you have anything that you wish to add?
I don't think that there is really anything to add. You've summarized it. I might point out just on the intangible issue, which the staff, I didn't hear them address it. Clearly, and this goes to prepaid expenses and prepaid contributions as well. Obviously, prepaid contributions and prepaid expenses can create an intangible asset, intangible right, as you have described, which can provide value in the future. So when you're, for example, when you're doing an income approach, it's quite well known that you have to account for the impact of that income approach that is caused by intangibles. Intangible assets generate income. You've got to take that out of the income stream that you're capitalizing. And here, that wasn't done for a couple of intangible assets. The contribution that was made initially, that creates an intangible asset for the right to participate. It also reduces insurance expenses in the future, which means it's increasing income. You've got to account for that in the income stream for these various intangibles that were identified. That's quite common. It's well established in case law and in the assessor's handbook, and staff hasn't done it here. That's all I'll say.
So with that, we'll close our rebuttal. Members of the board, thank you for your time, and we're here to answer any questions you may have.
Great, thank you very much. Yes, Mr. Schaefer?
I lost Mr. Dokasian. Before I came on the board, the fires came out in 2017, is that right? Haven't you been able to get together with the 2017 board and settle some of these issues? I mean, my beard is growing. It's 5 years later, and we're still talking about 2017, pardon me.
Well, I can't speak to what happened in 2017. I think what I could tell you is our approach and my client's overall approach, which was to try to work with the staff and with the board whenever possible. We just feel that we're in a situation here where the value is so out of whack that is what has brought us to the point that we are. So I apologize. I don't have any greater perspective I can offer you on 2017.
Well, I appreciate your argument, willing buyer and willing seller. I'm the businessman's advocate on the board, I think, and have been in many enterprises and appraisals as an individual. And I hope that we can come with some understandings and definitions that if there are other fires in our lifetimes, we'll have some of the answers and not have to start from the beginning again. And you're Mr. Mall, is he related to Milton Berle? That's the Mall family,
No, Mr. Schaefer, I'm not, at least that I know of.
Thank you.
All right, let's refocus in on the hearing. Mr. Gaines, do you have any questions?
I've got comments.
Comments,
so-
please, go ahead.
Okay, great,
And then we'll
thank
get
you.
down there.
I want to thank Southern California Edison for bringing this forward. And I've been consistent in years past in saying this, that I think their arguments have validity and that we ought to be taking a closer look at those arguments. And when we take a look at the income approach versus the cost approach, we have adjusted that for other entities. As the nature of a particular entity changes over time, this board and staff have made adjustments to that. And I think given the circumstances that they're describing, it justifies taking a look at these additional exposures, wildfire, climate change, and things of that sort. Just from the wildfire exposure aspect, I'm in the insurance business, and so when I take a look at the challenges that we've had with trying to insure property in California, it's a crisis. The insurance industry for the last 3 years, this year excluded, I think we dodged a bullet this year, had $4 billion a year in losses in each of 3 successive years. And prior to that, they had profits for a decade. So the profits for the decade prior were wiped out as a result of the catastrophic losses that occurred 3 years in a row. And just from a market perspective, it's very, very difficult to get fire insurance in the state of California, which tells me that the bean counters are looking at the exposure in the state, and they're saying, we can't make money in California when we sell fire insurance. And literally many of our markets are either shut down on a moratorium or they've pulled out altogether. And it's just not our markets. You take a look at Geico, they shut down 38 offices here in the state of California that were offering insurance. You've got Allstate that shut down its avenue through independent insurance agents. You can't offer coverage that way any longer. So the exposure, my point is the exposure exists. It's real. If the insurance industry thinks it's real and it's not offering coverage here, then in my opinion, the exposure will continue into the future. And that brings me to the $2.4 billion contribution described as a one-time payment. I just find that hard to believe given the exposure that still exists in California. It wasn't long ago that we had the Dorado fire that went through my district, my county, where I live. We dodged a bullet, in my opinion, that didn't burn down Lake Tahoe. So the exposure still exists, and we've got an insurance crisis on our hands. So I think that should be an annualized payment and considered as such by the Board of Equalization. And I think there was a good point brought up in terms of what would a willing buyer pay. And I do think that a buyer looking to buy assets from a utility or buy a utility would be looking at these same issues, these same exposures, and it would reduce its value. And then finally, I think they make a good argument on the equal protection issue. It seems like a valid point, and I guess that'll be determined in a different venue. But I still agree with many of the arguments made by Southern California Edison. And when I take a look at a utility and how they function, utilities are allowed a rate of return, and then there's a certain cost to produce energy, and then there are taxes to be paid by that utility, whether it's property or income taxes. But by increasing the tax exposure on a utility, aren't we ultimately hurting the consumer in terms of the rate? Because I would think if the taxes are higher, then they're going to have to increase rates to pay for that additional exposure. And I just feel like everybody needs to pay taxes, but given the circumstances that have been presented today and in years past, I think their arguments are valid. Thank you.
All right, thank you. So I have a couple questions that I just want to pose before we move on down the dais. And I would like to ask that the BOE staff attorney clarify for the record that the petitioner has the burden of proof when appealing to the board adopted unitary value. Is that correct?
That is correct.
Okay. And another question. I wanted to ask that the parties explain whether the 1.6 billion spent on the wildfire mitigation capital expenditures has any value that should be reflected in the property tax valuation calculations.
Yes, we do think there's value because it is part of the system. So unitary value is taking a look at the entire system, and it's all working together to generate income. Despite the financing that may be happening with those expenditures in the background, these items are connected to the system, and so there is a value that they're producing in terms of affecting income.
Okay, thank you. So this question is, oh, go ahead, Mr. Jakessian. Do you want to respond?
I did, to a couple of points.
Please.
First, Madam Chair, yes, it's true that we have the overall burden of proof in this hearing. My point was simply that if staff were to make an assertion, it's not up to us to disprove it. So they've made an assertion regarding regulatory lag and have come up empty. So it's not up to us to disprove every point that staff makes. And that's just sort of basic evidentiary procedure. It's effectively an affirmative defense is what it is. So it's not up to us to disprove their affirmative defenses. That's point number one. Point number two, regarding the 1.6 billion in value, I'm not sure that is the right question. And the reason is that it's not value in the abstract that we're looking at here. We're looking at whether it should be included in the historical cost indicator. Those are two different questions, right? So I guess I could say, like, look, they allowed the equity portion of the return, in their words. Is that an exemption? Does that have value? Of course it has value in the abstract. So according to their logic, nothing should have been taken out. But they did take out the equity portion. So it's not whether it has value in the abstract, it's whether it belongs in the historical cost indicator. And the reason that I'm underscoring this is the historical cost indicator is there to measure earning power. That's what it is. That's what the WASADA manual says. That's the purpose behind the historical cost indicator. So if you're not earning on the assets, they should be taken out. If you're not getting a return of the assets through depreciation, they should be taken out. And that's what's happening here. So if they were using like a replacement cost or a reproduction cost or some other approach to value, then maybe we could have a discussion about whether these assets should be included, but not in the historical cost context. Anyway, we also have the point about the intangibles, right? So if we're going to go in that direction, the capital expenditures create government rights for Edison, rights for a favorable prudency standard, rights to a limitation on the wildfire fund reimbursement cap, and those are intangible assets, so they need to be removed in any event. So that's our position on that. So it's not whether they have value in the abstract, it's whether they should appropriately be included in the HCLD and separately whether they're an intangible. Thank you.
All right, thank you. Mr. Vasquez, do you have any questions?
Yes, this is for the petitioner. In regards to issue 1 and 2, why is the rate-based regulated utility does like SC or SCE believe that the department's calculation of HLCD indicator is less reliable despite the HLCD being considered to be one of the more important indicators of value closely regulated by utilities based on relevant appraisals, principles, and board guidance?
It's a great question, Mr. Vasquez, and I appreciate that. So the reason that we say that is, yes, in many contexts, HCLD would be appropriate. In this case, it's not. And the reason is that under your own regulation, Rule 8, it says that the income approach is the preferred approach where the property has suffered considerable physical depreciation, economic or external obsolescence, or is subject to legal restrictions on income that are unrelated to cost. And that's what we have here. We have largely older assets. We have the entire wildfire situation and the regulatory overlay, all the expenses that are associated with that. And ultimately, for that reason, the income approach is the preferred approach, just based on the criteria in Rule 8. And I'll just bring you back to sort of one of our major themes, as you can tell, is willing buyer. What is more indicative of fair market value than what a willing buyer would pay for income producing assets? No reasonable investor would pay more for assets than the income that those assets generate. So the income approach should be the approach used, particularly here, where we have such a great disparity between the historical cost and the income, $8.5 billion, which your own handbook says may indicate significant obsolescence. Those are significant differences. I hope that answers your question, sir.
It does, but now it raises another question for staff. Do we have the attorney? I think he was on board here.
Yeah.
Yes.
I'd like to hear his rebuttal on that.
I'm sorry, what was the question?
I was asking the petitioner, why as a rate-based regulator utility does SCE believe that the department's calculation of HLCD indicator is less reliable? And he went into his explanation for it, and he's telling, or at least his argument, it sounds like it's that your staff is basing it on a measure that is not reliable. Or isn't up to date, I guess.
Yeah, so, I mean, going back to general appraisal theory, HCLD is the most reliable for for utilities of this type. When it comes to the difference between the HCDL and CEA, which this is all about, there are a number of reasons why those could be different. And I know in years past, we've talked about regulatory lag. There are some other things that it could be, and so there has to be an analysis of that to try to break down and understand what it is. And it requires a lot of cooperation and input from petitioner, cooperating with SAPD to get to the bottom of that. But at this juncture, when we're looking at the CEA and we're looking at different things, staff continues to believe that HCLD is the most reliable.
Thank you.
Controller Yee.
Thank you, Madam Chair. Some comments and then some questions. First, just as I appreciate the question, Madam Chair, you posed about the burden of proof, which is the case in all of these types of matters. And I wanted to just talk about the approach that staff took, which I thought was quite a fair approach, because there are different ways of looking at how we make significant valuation adjustments. And it's not just about the weighting of the value indicators, but also about just looking at the types of adjustments relative to each of the issues that Mr. McCool enumerated. So there's been quite a bit of adjustment already made to the valuation. I think about $2.6 billion, almost close to that. Is that right? Okay. So so that's one point. But I guess what I would say is I think the work that we do here in terms of valuation, property valuation, unitary evaluation, has to in some ways continue to mesh with what the PUC does with respect to just rate-regulated utilities. It is, I think, the HCLD indicator, I think, is probably the closest that approximates just what the PUC looks at relative to how it does its rate cases. And so there's a reason why we've been doing it the same way for a very long time. And unless the utility is going to anticipate a sale or just some consideration of what a future income stream may be able to help recover, I don't know that that's an appropriate debate for this particular matter. But and I also think we've been kind of conflating, because we've seen these issues before in a prior appeal. And to the extent that the burden of proof is on the petitioner, I don't know that we started this 2022 lean year process with really an understanding of the adjustments in the prior year, which came in, I think, during appeal by the petitioner. So I think, again, kind of the burden of proof about just, why these value indicators are assigned the way that they have been by the petitioner is still unclear with respect to how the staff is looking at this. But as a general matter, so we have this kind of AB 1054 that puts some parameters around this whole wildfire issue. And to me, the case really kind of is about how we would look at assessing any other unitary property of a rate-regulated utility, but for the application of AB 1054. So, which required Edison to make the $1.6 billion in capital expenditures over the 3-year period for fire risk mitigation, precludes Southern California Edison from earning an equity return on the capital expenditures, and this is also an area where the staff did make an adjustment for the inability of Edison to earn that equity return on expenditures, and that was, I think, the $513 million value reduction. So even with the application of the legislation, I think the staff went beyond just to look at some of the limitations that were made by that legislation on the utility and continue to make adjustments there. And I guess all told, what I'm hearing, having heard these issues in the prior year with all of you, is that there just seems to be a conflation of just looking at the concerns with respect to the valuation of Edison's property as compared to concern over the valuation of its business. Clearly, we're here to look at the unitary property value, but certainly the value of Edison as a business, as a going concern, is something that obviously the utility will continue to focus on. But I believe the issues that we are seeing here are relatively clear in that The adjustments have been made, as Mr. McCool described. I believe the value indicators that staff is recommending are appropriate, and I do think that we have a bit of a responsibility or an obligation to stay as close to just how we are guided and really how the PUC is guided by how we look at the valuation of these rate-regulated utilities. So I just wanted to put that out there. And my question really has to do with, I guess, to the petitioner about kind of what the starting point of this year's 2022 lien date valuation process was, because we did hear this in the prior year, and there was an adjustment made on appeal, but I'm not sure that I really understood the rationale for that, and was that rationale brought forward with respect to this lien date valuation? And I'll ask Mr. McCool to comment on that after the petitioner.
I'm Madam Controller, I'm sorry, I don't understand your question.
So in the prior year, there was an adjustment made on the weighting of the indicators, and I think that came in on appeal.
An adjustment made on the weighting of the indicators? No.
No?
No adjustment was made.
I thought there had been one. Okay.
I thought there was one as well. I think there
We're
was.
still at 45.
I thought there was, it began like a 50-50 and it came down to 35 on the income indicator? Or am I getting
Okay.
it wrong?
All right, there's some confusion.
Maybe I'll ask staff to.
Dan, do you,
Staff.
pardon me, yeah.
Yeah, sorry.
Chair Cohen, could Dan maybe speak to that?
Yeah, this is Dan Jenkinson with SAPD. I'm sorry, I was going to just jump in real quick. I'm not sure if, I know that there was a roll correction that we made. There was like an adjustment that needed to be made. And so I think maybe that's what you might be thinking of. But I don't think it was related to the weightings. It was just related to some adjustments that SE had requested that we make to the appraisal directly after the appraisal season. So that might be what you were thinking of as far as an adjustment.
All right, I apologize because there was an adjustment. All right. So, and maybe back to you on the question then with staff. So what was the, so what did you see with respect to, or what would you have needed to see to justify the weighting? I know the burden of proof is on the petitioner, but I guess what was the starting point with respect to looking at the 2022 lien date valuation?
Jack or Dan, could you guys step in and answer that?
Yes, so sorry. Jack McCool, State Assessed Properties Division. To your question, Controller, our staff has spent a considerable amount of time over the last several years looking closely at the value indicators for the large utilities and, of course, the related issues. And we've sought out as much information as possible. And we've been poring over the data that we can find in order to constantly evaluate our indicator weightings. After last year's oral hearing, one of the large utilities actually reached out to us and offered to work with us on further examining, for example, the issue of regulatory lag. And our staff actually examined documents and information provided by the utility, and it did prove to be very insightful. And I think it's important to point out that while our staff was looking at those documents, we weren't just looking into the issue of regulatory lag specifically, but also the effects of other components that make up the utility's filings with the PUC. Our goal has been to better understand what could be accounting for the difference in the value indicators and for some of the utilities, and also to see what type of information would be available if we did need to do a deeper analysis. And the bottom line is that this is very complex and would require a considerable amount of information from the utilities to provide to us, and also a considerable amount of time and resources internally to analyze. I think it's important to remember that we typically rely on the assessees to provide us with information or studies in order to substantiate changes in our appraisal methodology or to substantiate obsolescence. The last time the indicator weightings were changed, one of the utilities actually presented us with a data analysis that quantified an increase of regulatory lag experienced during a period of large capital expenditure growth. That specifically resulted in SAPD staff at the time changing the weighting from 90% HCLD to 10% CEA to what we currently have. We are trying to devote more of our resources internally to monitoring the PUC proceedings and reviewing the information submitted to the PUC more thoroughly. We are also aware of the prospect that future rate cases may be decided every 4 years rather than the current timetable of approximately every 3 years. And that is certainly something that we're going to continue to keep our eye on. After careful consideration of all the information we were able to obtain this year, and absent any specific study or data to support an alternative weighting, we felt the current 75-25 weighting for the large utilities continues to represent the best weighting for these two indicators, consistent with the accepted appraisal theory regarding the valuation of closely regulated utilities. And that's consistent with appraisal guidance. The HDLD indicator is preferred when we're valuing these utilities because the PUC uses the historical cost as its rate base. So we are using the actual amount invested in the property. In other words, we're using the cost of the property less depreciation as a relevant value indicator. And all of the appraisal texts state that the difference between the HDLD and the CEA, or the income indicator, can occur for a variety of reasons. And some of those we've looked into, including accounting differences. We've mentioned regulatory lag. We're looking also at how there could be management decisions or differences in the forecasts that were submitted originally to the PUC for the rate case filings. All of those can be contributors to the difference between the indicators. We continue to be willing to work with the utilities, and any that wish to assist us in looking deeper into these topics, we will certainly welcome that cooperation. I want to also mention that we've reached out to our counterparts in other Western states. As petitioner has mentioned, Western States Association of Tax Administrators, we are a member of that organization. We have staff on the committees related to central assessment. And as you know, wildfires have not been unique to California. They've caused considerable destruction in other Western states. We've engaged our counterparts in the appraisal field in other Western states the last few years on the issue of wildfire and climate change. And what we've discovered is that no other state is currently making value adjustments due to the wildfire issue. So we will continue to closely monitor the issue as we've done the last several years. We now have, of course, we've had the rate cases in the past. We have AB 1054, so that's legislation that addresses the issue. And as the PUC has stated, they believe AB 1054 appropriately mitigated the risks that the utilities face. The legislature designed AB 1054 with that in mind. And we will continue to engage with the utilities as we always have, and we'll do our best to evaluate any information that they provide on wildfire, climate change, or any other issue. And I'd just like to point out that we've made the same adjustments for wildfire as we have in the last 2 years, again this year, and we've worked with the utilities, and some of those adjustments were actually created in cooperation with utility representatives when we created them in the first place, or calculated them in the first place. So we continue to cooperate and look for as much information as possible. But we have spent a considerable amount of time analyzing as much information as we can, and hopefully that's answered some of your questions.
Yeah, that's very helpful. Thank you. Mr. Jacasey, did you have anything to add?
I did, Controller. You know, so it sounds like everybody understands there's been no adjustment made to our weighting, but adjustments have been made to the weighting of other taxpayers. We make a concerted effort to work with staff every year. We spend a lot of time and effort, and nobody has reached out to us on this specific point. So there have been adjustments made to other investor-owned utilities. I mean, we'd like to have that same consideration.
Members of the board, just to clarify, after all this analysis, we have not changed the weighting indicators for any of the large utilities based on our analysis,
Okay.
just to be clear. Thank you.
Right.
Yeah, I apologize if I misunderstood that. Yeah, in terms of Controller sticking close to the CPUC, I think we could all agree that the background and what's taking place at CPUC is important. But I would go back to the WSATA manual, right, which is that the regulatory agencies are in the business of setting rates. They're not there to determine or even estimate fair market value. So while it's important as background, I don't think that it is that the CPUC should be the arbiter of what is or what isn't a fair market value for these utilities.
I just wanted to note something on that point. we acknowledge what Wasada handbook says, but there's, in the appraisal world, HCLD is not equal to rate base. So there are other adjustments that are going to be made. So while HCLD is very important because it approximates rate base, it's not a one-for-one comparison. So there are other adjustments that are made.
I don't disagree with Mr. Lujan on that point.
Yeah, I appreciate the clarification. Thank you. You know, on this issue of the insurance payments, I think the argument about whether we will see this amortized expense be recurring due to the new reality of wildfires. I mean, this is an unknown, but I think this also, at least for this body, relative to that, I think it's really more about the treatment of that initial contribution, which I don't think anybody has any dispute over that. And what the legislature decides beyond AB 1054, I think, still remains to be seen. So I don't know that anybody can hazard a guess on that piece of it going forward. Thank you, Madam Chair. I really appreciate the work of the staff on this matter. It is complex on one level, on the other level, not so with respect to just how we have looked to apply the value indicators for this particular group of state assessees. Thank you.
Thank you. All right, colleagues, are there any other questions? Okay, Mr. Gaines has point
Yeah,
of
just
clarification.
if I could, a point of clarification in terms of adjustment to income approach versus cost approach. I still stand by my statement. It's an accurate statement.
Okay,
Madam Chair, may I comment on something?
please, yes.
Thank you. So there was a comment made earlier by Controller Yee about conflating the business and the assets. We're not doing that here. We're talking about appraisal of the assets. And so we're not talking about appraisal of the business, we're talking about appraisal of the assets. And so particularly in a situation where you're talking about the claims and the claims can't be separated from the assets, yes, the claims adversely affect the business, but because the assets are regulated, they also adversely affect the assets. And then in terms of the preference versus of HCLD versus income, Madam Chair, I understand, Madam Controller, I understand your point. I'm getting confused between the controller and the controller-elect. My apologies. In terms of the use of the income approach versus HCLD, I don't think we should limit our reliance on the income approach to situations where a pending sale is imminent. I'm not saying that you suggested that, but I think someone could take that from the comments you made. I think the income indicator is crucial because that's the ultimate measure of what a willing buyer would pay for these assets. And I think that's the reason we're seeing the disparity. I still haven't heard anybody in this room explain why these two value indicators are $8.5 billion apart. After all this, I still haven't heard anything. So that's why, I mean, the income indicator, let's look to what the market would pay, what a willing buyer would pay for income producing assets. Thank you.
Thank you.
I appreciate the clarification, Mr. DeCasian. That was not my intent with respect to looking at the income approach. I do think the staff applied the income approach appropriately, but I think the overriding value indicator as relates to this particular assessee, it's the HCLD approach. So, and we are talking about kind of the weighting that's in dispute. And I think the reconciliation of the value indicators, the staff has really relied on our property tax rules with respect to how to apply each of those appropriately. So I did not mean to have the income approach be viewed exclusively just for when there might be an imminent sale.
Okay. All right. All right, seeing that there are no more further comments, Mr. Keddy, do we need to take public comment on this item?
Yes, we do.
All right, let's go ahead and take public comment.
Maybe we could do a motion first before we go out to the public comment?
All right, staff, or colleagues, is there a motion for this item?
So move.
Okay, let's get a motion to accept the staff recommendation. Okay, all right, motion to accept the staff recommendation has been seconded by Controller Yee.
All righty, let's go out to the moderator. AT&T moderator, Can you please tell us if there's anyone on the line who'd like to make a public comment regarding this item?
For public comment by phone, please press 1, then 0 at this time. An operator will gather your name and place you in queue. When you hear your name called, you may proceed with your question. Press 1, 0, please. Madam Chair, we have no one in queue.
All right, thank you. And just for clarification, the motion was made by myself and seconded by Controller Yi.
Take the roll.
Yes, please.
Chair Cohen,
Aye.
Vice Chair Schaefer,
Aye?
Member Gaines,
No?
Member Vasquez,
Aye.
Controller Yi.
Aye.
All right, this motion passes. Thank you. Ms. Giacchetti, it is 12:02. Are we due for a recess?
Yes, I guess it depends on Ms. Yi's schedule, if she's
Okay.
available, or we could continue on
Commission-
with the other constitutional functions.
We can continue. I'm just trying to be sensitive to the staff that need maybe a 5-minute break or water break or bathroom break. 5 minutes?
Let's do a
Okay.
5-minute break.
Okay, we'll take a 5-minute break. We'll take a 5-minute recess. Thank you. We will reconvene at 12:07.
Chair, I'm surprised they have an hour lunch.
All right, good afternoon, ladies and gentlemen. We're back in session. Ms. Cicchetti,
The
please
next
call the-
item,
Thank you.
The next item on our agenda is E, tax program, non-appearance matters, adjudicatory, legal appeals, property tax matters, petition for reassessment of unitary value. There are three items. A, Dynergy Morse Landing LLC, 1103 SAU 22-011. Second one is B, SFPPLP 0461 SAU 22-015, and C, Cal Neve Pipeline LLC 0402 SAU 22-016. All parties have waived their appearance and have not waived confidentiality to the record. This is a constitutional function. The first case is E3A, Dynegy Morse Landing LLC, 1103. Contribution disclosure forms are required pursuant to Government Code Section 15626. Board Proceedings has received contribution disclosure forms from the parties, agents, and participants. No disqualifying contributions were disclosed. All parties, agents, and participants are listed on the memorandum provided to your office. This matter will be presented by Ms. Yim.
Thank you. Ms. Yim, good afternoon.
Good afternoon, Chair Cohen and honorable members of the board. Again, I am Sonia Yim, the appeals attorney for the State Board of Equalization assigned to this case. I have submitted a summary decision for Dynegy Moss Landing LLC for your consideration. In this case, the petitioner has waived their appearance before the board and is requesting that the board decide this petition based on the written record. The petition raises one primary issue: whether proper reliance was placed on the cost and income value indicators. Based on the written record and as reflected in greater detail within my summary decision, I recommend that the board deny the petition for reassessment and reaffirm the 2022 board-adopted unitary value of $289,800,000. I ask for the board's adoption of my recommendation.
All right. Thank you very much for the recommendation. Let me see if my colleagues have any question. Any questions on my right? Nope, nope. Okay, great.
Need a motion?
Yes. Let's have a motion.
I move staff recommendation.
All right, so a motion made by Mr. Vasquez, second by Ms. Controller Yee. Let's call the roll.
Chair Cohen?
Aye.
Oh, I
Oh,
apologize.
do we get public?
Oh, public
Yeah,
comment, that's correct.
right.
Thank you
I
for the correction.
apologize.
Let's go to the public
AT&T
comment.
moderator, do we have anyone on the line who would like to make a public comment regarding this item?
For comment regarding this item, please press 10 at this time. Madam Chair, we have no callers in queue.
All right, appreciate it. Let's call the roll.
Chair Cohen?
Aye.
Vice Chair Schaefer?
Aye.
Member Gaines? Not present. Member Vasquez?
Aye.
Controller Yee?
Aye.
Motion passes. The
Excellent.
second case is E3B, SFPP LP. Contribution disclosure forms are required pursuant to Government Code 15626. Board Proceedings has not received all contribution disclosure forms for the parties, agents, and participants. No disqualifying contributions were disclosed on the forms received. All parties, agents, and participants were listed on the memorandum provided to your office. This matter will be presented by Ms. Yim.
Thank you, Ms. Cicchetti. Members, in the case before you, the petitioner, SFPP, has waived their appearance and is requesting that the board decide this petition based on the written record. The petition raises two primary issues. First, whether the respondent erred by not including an adjustment for economic and functional obsolescence in the assessee furnished estimate of rate-based value indicator. And second, whether the basic capitalization rate should be increased to account for additional extraordinary risk. Based on the written record and as reflected in greater detail within my summary decision, I recommend that the board deny the petition for reassessment and reaffirm the 2022 board-adopted unitary value of $419,400,000. I ask for the board's adoption of my recommendation.
Thank you. Is there any discussion on this item? All right, seeing none, let's take public comment.
Let's get a motion first, please.
Approve. Oops. Move to adopt staff recommendation.
All right, a motion has been.
Second that.
All right, so a motion to adopt was made by Mr. Vasquez, was seconded by Controller Yee, and now we're going to go to public comment.
AT&T moderator, is there anyone on the line who'd like to make a public comment regarding this item?
For public comment, please press 10. Madam Chair, we have no callers in queue.
All right, thank you. Let's call the roll.
Chair Cohen,
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines is absent. Member Vasquez,
Aye.
Controller Yi. Motion passes. The next item on the agenda is E3C, Cal Neve Pipeline LLC. Contribution disclosure forms are required pursuant to Government Code 15626. Board Proceedings has not received all contribution disclosure forms for the parties, agents, and participants. No disqualifying contributions were disclosed on the forms received. All parties, agents, and participants were listed on the memorandum provided to your office. This matter will be presented by Ms. Yi. I'm sorry, Ms. Yim. It's almost lunchtime.
Ms. Yim is quite ready to
Go ahead,
present.
Ms. Yim.
Thank you. Members, in the case before you, the petitioner, CalNev Pipeline, has waived their appearance and is requesting that the board decide this petition based on the written record. The petition raises two primary issues. First, whether the respondent erred by not including an adjustment for economic and functional obsolescence in the assessee furnished estimate of rate-based value indicator. And second, whether the basic capitalization rate should be increased to account for additional extraordinary risk. Based on the written record and as reflected in greater detail within my summary decision, I recommend that the board deny the petition for reassessment and reaffirm the 2022 board-adopted unitary value of $83 million. I ask for the board's adoption of my recommendation.
All right, thank you. Questions, comments? Seeing none, thank you. Is there a motion to adopt?
Move staff recommendation.
All right.
Second.
Motion made by Mr. Vasquez, seconded by Ms. Yi. Let's go to public comment.
AT&T moderator, is there anyone on the line who'd like to make a public comment regarding this item?
For public comment on this item, please press 1-0. Madam Chair, there are no callers in queue.
Thank you very much. Let's call the roll.
Roll. Chair Cohen,
Aye.
Vice Chair Schaefer,
Aye.
Member Gaines is absent. Member Vasquez,
Aye.
Controller Yi.
Aye. Aye, excuse me.
All right, motion passes
passes.
unanimous. Let's call the next item.
The next item is Other Tax Program Non-Appearance Matters, F1A, Board Roll Changes, 2022 Board Roll of State Assessed Property. This matter will be presented by Mr. McCool.
All right, Mr. McCool.
Thank you. Good morning again. Oh, actually, good afternoon, Chair Cohen and honorable members of the board. I am Jack McCool, Chief of the State Assessed Properties Division. Revenue and Taxation Code Section 4876 allows for the correction of errors made to the board roll of state assessed property. I'm here today to present two roll changes to correct staff errors for the board's consideration. Both roll changes involve the same error. Both assessees filed petitions in 2021 for reassessment of their unitary property. The board adopted petition adjustments for both assessees. Normally, petition adjustments are applied as adjustments to the roll in the following lien date. However, both of these assessees requested that SAPD correct their 2021 assessed values to reflect the petition adjustments. SAPD complied with the assessee's request. Unfortunately, staff erred by applying the petition adjustments to the assessee's 2022 assessed values as well. So essentially, we applied the adjustments twice. The adoption of the roll changes before the board today would correct that error. Both state assessees have been notified of the error and are aware of the roll changes before the board today. As is our practice when errors are made, we have reviewed our processes and we have made changes in an attempt to ensure that this type of error does not occur in the future. Thank you for your consideration, and I ask for the board's adoption of these roll changes. Thank you.
Great, thank you. No discussion. Let's just go ahead. We'll take a motion. Let's go to public comment.
We usually like to get the motion first
Oh,
before
okay.
we go to
I thought it was the
public
other way
comment.
around. All right, let's, a motion.
Move this,
Second.
All
adopt
right.
staff recommendation.
All right, thank you very much. Motion made by Mr. Vasquez, second by Ms. Yi. Let's go to public comment.
AT&T moderator, is there anyone on the line who'd like to make a public comment regarding this item?
For public comment by phone, please press 10. Madam Chair, we have no callers queuing up.
Thank you.
Thank you. Let's call the roll.
Chair Cohen,
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines is absent. Member Vasquez.
Aye.
Controller Yee.
Aye.
Motion passes unanimously.
The next
Next item,
item is the
please.
special presentations. Special presentation to State Controller Betty Yee and Chair Malia M. Cohn. This matter will be presented by the Executive Director, Ms. Stowers.
Good afternoon. Good afternoon, Chair Cohen and members. I am Yvette Stowers, Executive Director. I would like to take a brief moment to make a special presentation to Chair Cohen and State Controller Yee. First, I would like to recognize Chair Malia M. Cohen. Chair Cohen was first elected to this board to represent the 2nd District and its 23 counties in northern central California in November 2018, and has served for almost 4 years as a member, including 2 years as chair in 2019 and 2022. During her tenure as the Equalization District member, her notable accomplishments include leading the statewide informational hearings on modernizing the California property tax system and co-establishing the property tax abatement work group to spur affordable housing. In addition, her leadership allowed greater access to limited non-English speaking individuals by establishing the transfer feature on the BOE's website. Chair Cohen was recently elected as the 33rd State Controller, and once again, our sincere congratulations. We are fortunate that Chair Cohen will remain on the board as an ex-official member. In honor of your service, I would like to present you with a gift.
Thank you.
But before, I would also like to make brief remarks for
The controller.
State Controller Yee. Today is State Controller Yee's last regular meeting as a member of the State Board of Equalization. And on behalf of the agency and all the employees, I would like to also thank you and recognize you for your almost 2 decades of services and leadership. Controller Yee served as a member of the State Board of Equalization for more than 18 years, 3 years as the chairwoman, 2007, 2009, and 2010. She first served as an acting member in December 2004 for the 1st Equalization District when then Chairwoman Carol Mignum was sworn into the California State Senate. She was subsequently elected November 2006 and represented the 1st District and its 21 counties in Northern and Central California for almost 8 years, 2007 to January 2015. Ms. Yee is known for her exceptional tax law knowledge and always deciding appeals impartially, objectively, and transparently. One of her greatest legacies and contributions during her tenure on the board was establishing the Open Data Portal, making essential data and information transparent and easily accessible to the public. In November 2014, Ms. Yee was elected as the 32nd State Controller and has served as an ex-official member for almost 8 years, from January 2015 to today. Throughout her tenure on the board, Controller Yee has demonstrated qualities of what is to be known as a noble public servant: integrity, wisdom, authenticity, inspirational leadership, empathy, respect for others, commitment to solving problems, and serving all of California. Controller Yee has been one of the most consequential state controllers and constitutional officers to serve California. Thank you for your leadership, your service, your mentorship, and on a personal note, your friendship. I also have a gift for you. Chair Cohen, With your permission, I would like to present the gifts and photo opportunities with the existing board members.
Thank you.
We'd like to go to the AT&T moderator today before we go to that portion.
Thank you. We'll take public comment.
Yes, I believe there's some people who would like to. AT&T moderator, is there anyone on the line who'd like to make a public comment regarding this item?
To make comment, please press 1, then 0 at this time. The queue is open. To make a comment, please press 1, 0.
Does the public have a right to comment on gifts?
Madam Chair, we have no callers queuing up.
Okay, thank you very much. Ms. Stowers, my colleague, Mr. Vasquez, would like to say some remarks before the presentation. Is that okay?
Absolutely. Yes.
Yes. I'll start with our Controller, Betty Yee. I'd like to just thank you for your service, especially to myself, and I imagine my colleagues share this as well, as we came on board, all new in 2018. And I think your leadership, especially on the governance policy, I understand you were kind of the author, the key author in this back in, I guess it was 2017. And because I think that really helped us, especially after AB 102 came to kind of guide us in terms of what we can and can't do. And I know many times, at least in that first year, it was a bit of a challenge for many of us because we were all new. None of us, we didn't have that institutional memory that you brought to the table. So I really appreciate you for that, and thank you for your service. And your institutional memory is going to be sorely missed on this board. But through your leadership and staff, and Brenda, who our former executive director, I think we did a pretty amazing job those first 2 years to kind of redirect the mission of the BOE, and now really just doing our constitutional duties. And I really appreciate that. And wish you nothing but the best moving forward. I'm sure you have bigger and better things in your future moving on. Now, to Madam Chair, it's been great serving with you these last 4 years. And I know, the two of us, we were new coming into this thing. And you took the challenge on right first year. You were dropped in as the chair. And all of us were new, and really appreciate your leadership in terms of giving us some guidance and just being open with us, because I know it was difficult for many of us because we were all new to this, and we were kind of trying to steer this ship in the right direction. And like I mentioned earlier, I think it helped that we had the controller for that institutional memory. But looking forward, but on an up note, you'll still be with us, now in a different role. And as the controller, I'm looking forward to our continued relationship and partnership as we move forward on many of the things that we started, especially on the affordable housing front and the whole modernization that you really pushed forward at the very beginning when we did our strategic planning. So looking forward to your new role and for your partnership and participation as we take, hopefully, the BOE to the next level. Thank you.
Thank you. Thank you. Okay, thank you. We will take a brief. Oh, you want to say something?
Yes, well, I just want to say, when I first came aboard, I was so impressed when the controller would be with us. She had so many other boards and places to be, and right after I got the nomination, she called me from Sacramento and gave me some advice and counsel on what the BOE was doing, and so I could be a more informed candidate, and that gave me some credibility I wouldn't have had otherwise. So I've just been so honored to serve with her as one of the many new people, that were on the board. As to Ms. Cohen being here for the excitement of the birth of her baby, and that's something we're all so proud and excited about. Wondered why I didn't come to the board earlier in life, knowing, what a life-changing event it could be. And I've grown in stature because of these two women being my mentors, and she picked the best people to be with us. Yvette Stowers, who's gone on to be our director. So I'm flattered to be working with giants in government. Thank you.
Thank you. Thank you for the kind words. Now we will take a brief recess, unless the controller has remarks. Sure, let's do remarks now.
Yeah.
Okay.
Thank you very much, Madam Chair, and congratulations to you. And I know we're all excited about your continuing your service on this board, but also coming in as the next Chief Fiscal Officer for the state of California. It's pretty awesome. So I wanted to just thank my colleagues. This has been a transition time for this board, and I do want to applaud all of you coming into this situation anew, not having been part of the thought process or the history of not just the institution of the Board of Equalization, but just also what people had contemplated with respect to what the future of this board would look like. And I think all of you have certainly served your constituents admirably. And I think, to your point, Mr. Vasquez, the work will continue in terms of just really trying to find, that body of work that's going to continue to be of value to our taxpayers, but certainly the relationship with our county assessors, and the work, as you say, on affordable housing, which is the number one, I think, public policy issue facing California. So to have this board weigh in on that with our jurisdiction, I think, is appropriate. I want to thank the members of the staff of this organization that also really had to experience the transition and the change with the prior Board of Equalization having been an appellate body, and which was where I did most of my work during my time here. But the caliber and the professionalism of the team here, and particularly now with our property tax experts, state assessed property, county assessed property, they really are a stellar team, and we rely on them. They are recognized as the experts throughout the state, and so just wanted to acknowledge them and all of the great work that they continue to do with all parties. To Ms. Stowers and to the executive team, thank you. And Yvette and I kind of grew up at the Board of Equalization together, so I'm very happy to see her leading this organization as the executive director, and very much know that she will continue to bring just the right amount of support that you all need to continue to do the work that you will consider a priority. I want to thank my Deputy Controllers for Tax Policy, Ms. Stowers, definitely, who has served me for my 8 years as a controller, Mr. Eppolite, who more recently joined as my Deputy Controller for Tax. Our work in the Controller's Office is beyond just the board here. Obviously, this includes the Franchise Tax Board, includes a lot of the budget-related issues affecting the tax arena, as well as looking at all the legislation that does go through the legislature that affects not just the Controller's Office and our tax programs, but also just taxation and tax policy more generally. I'll just say this about this board and what I've learned. I think the leadership lesson that I've learned from this board, and it's been a good lesson because it's what I've brought to many of the other boards on which I've had the opportunity to serve as controller, and that is, the leadership, particularly sitting as a chair, and Ms. Cohen's been very collaborative here, certainly as our chair, and that is you're really the first among equals. Nobody really signs up to be a chair to, kind of want to take on more responsibility, but that's exactly what you do. But it is to say that you're first among equals, to be sure everyone has equal opportunity to participate. And I think certainly during this time of where we are trying to move to the other side of this pandemic and how we've had to transact business, Chair Cohn and Mr. Vasquez, both of you, really led that. And I think our public reach has been really beyond expectation given the environment in which we've had to work. So just really congratulations to both of you for encouraging that. And the other lesson that I will learn is that we have adversarial relationships and we have relationships that are more supportive. But at the end of the day, this is true of this board, of any board, it always has to be just conducted in terms of how we do our business with the utmost respect. And I think that is something we can all feel proud of with respect to this board. So congratulations to all of you. I will miss you. I will miss this board. It has been such a formative part of my professional development, and I will always remember this experience. Thank you.
All right, with that said, let's recess. Mr. Kitty, is it best to recess for lunch at this point?
Well, let's recess for photographs and then for our lunch hour, yes.
Okay. What time will we reconvening? What time is it? At 1:30?
Yeah. 12, 1:30? 1:30?
All right. All right, for the members of the public, we are going to go in a brief recess for lunch and to take pictures, and we will reconvene at 1:30. Thank you. you.